Come to page number 21. On what ground I have been rejected? Page 21.
21. Yes.
This is the minute of the technical weight evaluation which is impugned before the lordship.
Yes.
Here we are in page in serial number 2 and 7. The list of the bidder were 9. Out of the 9, 2 has been responsive.
It is by both the bidders.
Yes.
The petitioners are joint
Petitioner by the.
Why joint? You should file a separate petition. File a separate petition.
That is the one my lord.
Ground may be same, but file a separate petition. So what is the reason?
My lord, may kindly see the
Appendix to ITB
Eka Enterprise,
yes.
Non-responsive. The reason is that my lord, the instruction to the bidder of the 4.4b B1, my lord, this is that is what given in the my lord instruction to the bidder. That my lord will find in the page number 31. My lord, may kindly come to the page number 31. This is standard bidding document for PMGS web.
Yes.
My lord, page number 31. Yes, 4.4b. And for the petitioner number 1, MS Eka, my lord, B at B1. Each bidder must demonstrate my lord, availability of the construction of work, either own or on the lease of the hire of the key equipment started in the appendix to the ITB, including equipment requirement for the establishment field laboratory to perform the mandatory test, and those stated in the appendix to the ITB.
That you have
ITB, my lord, the instruction to the bidder. My lord, the claim is that this has not been, my lord, annexed, but my lord, our submission is that we have annexed it after the my lord, this impugned evaluation. We have downloaded the document from the my lord concerned department, and the same has been annexed as my lord annexure D. My lord,
so you file a separate petition. We'll take up on Monday. Otherwise, are you in collusion? Both the bidders.
Otherwise, my lord,
are you in collusion?
No, my lord.
Then file a separate petition. And separate ground also. Rejection is on separate ground.
Oh, almost similar. Almost similar.
1 into. Almost not similar. Different ground.
Can it be, my lord? Can that be, my lord? This
you file a separate petition. Huh? Monday will take up. You file it today or tomorrow.
My lord.
Okay.
My lord, what I am trying to
the understanding of this court, when there is a common cause of action, then there may be a joint petition. This is a separate ground of rejection, and even if you are allowed, I mean, different, we look into different.
My lord, that I admit, man. My lord, may I pray that
Mr.
let the
learned counsel for
petitioner number 2 be struck off, and this petition be, my lord, for the petition of.
Then in that case, you have to file an application.
My lord, both petitioners are competitive bidders.
No, that's what I'm saying.
The conduct itself shows connivance between these two bidders.
So that ground will dismiss today.
Different.
Mr. C. Modi, learned counsel for the petitioner. President, the present petition may be allowed to withdraw. Allowed to be withdrawn. A press for withdrawal of the writ petition with the liberty to file the fresh. Fresh allowed. Petition is disposed on withdrawal with a liberty as spread. You are considerable, Modi. You are a senior now. At least this basic thing should strike to your mind.
Yeah.
Or who has drafted and has it been engaged to you? Somebody has drafted and filed it and engaged to you. Is it the case?
Sometime, but not in this case.
Shortcut. Okay.
My lord, kindly pass over the matter for typing, item number 6 and 7.
What is there? What remains there now?
Okay. Pass over, item 7.
My lord.
6 and 7. Possible for family.
My lord.
Yes.
This matter also pass over for time being, my lord.
My lord, this is a bail application. My lord, the bail application is for seeking the bail to accuse Asadul,
Statutory bail, 167.
yes, 167.
What is the offense, the punishment?
Punishment is section 21B of NDPS Act.
Let us see NDPS. Where is the PP? Sir, statutory bail,
Yes, my lord.
167.
Yes, my lord. Here in this case, my lord, the accused was arrested on
What should be the statutory period?
60, my lord.
60 days.
Yes, my
When you were arrested?
lord. 2nd of September. Now it's 75 days. They are in custody.
So, will allow?
Yes, my lord.
Or Mr. So-and-so, then consider the petitioner. Also heard Mr. Jayasiri Lalit consent, Lalit considered for state of Arunachal Pradesh. This is an application. Under section 439, read with 167. Within bracket 2 of CRPC, 1973. For release for statutory public default bail to accuse person namely Sakir Ahmed.
Sakir Ahmed and Amirul Islam.
No, that will have a separate
first
name will be changed. Sakir Ahmed in connection with usually PS case number 82 of 2023 under section 21 within bracket small b of NDPS Act 1985. Where is the FIR?
Nineteen, relevant. Page number 19.
Taxpayer. The case set up by the prosecution is that an FIR was launched by one city. What is the name of this? PCM.
PCM.
Inspector. Police station, Nirjuli.
Yes, madam.
Nirjuli
Literally.
doesn't show anything. That a reliable information was received from a source that on 1/9/2023, one person was going to deliver huge quantity of narcotics within bracket heroin at Bandipur / Nirjuli place Naharlagun area. Accordingly, information was conveyed to the SP Naharlagun region. He verbally directed, assigned to, verbally directed the informant to constitute him. Subsequently, under the supervision of SP Naharlagun Public Region, informant along with police officers and constables left the police station to locate the peddler and also called the executive magistrate and the independent witness company church and freezing. On the basis of input, operation to intercept and the peddlers. The police team laid a trap of 6 o'clock. You just page 19, huh? You just accordingly. Next paragraph. The affair was registered. The PS case number 82 of 2022 under section 2021. Under section 21 within bracket small b in the PS Act. Listen. And when you were arrested? And
2nd September, page number 21.
pursuant to next paragraph, the accused so and so was arrested on 2/9/2023. And since then, he is languishing in the jail. This next paragraph. The learned counsel for the applicant the accused is in jail for more than 75 days.
75 as of today, 75.
74 days.
74 days till yesterday.
74 days. As on then since his arrest. Because he is and the investigating authority, not investigating, the officers, the police has failed to file the charge within the stipulated period of 60 days. Thus, the accused is entitled to be released on released on default bail under section 167 within bracket 2 within bracket
1672.
167 2 bracket close to bracket small Roman 2
Small a.
small a
Roman 2.
Roman all small Roman 2 all bracket here 1973. Next Mr. Yes, regular public prosecutor fairly submits that isn't that no charge sheet has been filed, which is of course a violation of stipulated period. Having considered the submission of the learned consumer purchase and considering that the police has not filed the charge sheet even after lapse of 34 days.
Yes.
Come on, this cottage of the view that the applicant, the accused, has the indefeasible right to be released of the default debt and by operation of the law. Accordingly, the petitioner, the accused shall be released on bail on furnishing a bail bond within forthwith.
What with subject to the
It depends on if he cannot furnish the bail
yes,
bond, he will not be released.
yes.
But they will say forthwith. Furnishing a bail bond, I need not say. On furnishing a bail bond, forthwith. All right.
Yes.
If he doesn't furnish, he will not be. Same or that. Name will be changed, different.
Deeply obliged.
You may, yesterday we have passed one order that Rakesh board, not same. This I've dictated you, you add that in one paragraph. Rakesh board, huh? When Supreme Court says same, so, huh? Ah, that paragraph you add that. Sir, what is this?
I'm sorry, my lord, I was in the other room. My lord, this is about medical reimbursement of medical expenditure, my lord.
What happened?
My lord, on the last date, there was a direction to file an affidavit. My lord, already 10 affidavits have been filed, my lord.
10 affidavit.
10 affidavits already filed, my lord. My lord, my mother died of cancer
Ah.
and she was being treated at Rajiv Gandhi Institute in Delhi. My lord, I
Let us see, let us see the last order.
my lord, 9/10/23, my lord.
Yes. Let's see, what is this additional affidavit? Have you filed the additional?
This additional affidavit is supposed to file by
Your
the,
Lordship, Ms. Puru Pangwe is the leading counsel here, Your Lordship, and
I don't consider.
she is absent today.
You are equally a leading counsel.
Yes, Your Lordship, I understand, Your Lordship.
As a government lawyer, you are equally have the same power and authority.
Yes, Your Lordship,
There is no question of leading or not leading.
brief is with her, Your Lordship.
earlier, he was representing the case.
Yes, Your Lordship.
My lord, sometime it may be given, my lord. I am told that she had to attend the funeral.
Or Mr. Within a learned counsel to the petition. Also had Mr. Gita Gumpo responding.
6 and 7.
Riram appearing, Y Riram, learned government counsel appearing on behalf of MSP Pango, stated to be a leading counsel in this matter.
Yes, Your Lordship.
And also Mr. Gita Group, learned counsel for the, learned study counsel for the
Health Department.
health department. I think you are the one who, or is the.
Well, this is the
Government
finance
has to
department. It's the finance
Government has
department
to take it.
because this is the case of reimbursement.
Mr. Y. Learned counsel for the petitioner. Learned counsel appearing on behalf of the state. And also on behalf of the state and MSP Pango submits that. The brief
Yes, Your Lordship.
of the matter is with learned counsel MSP Pango, for which he seeks 3 weeks time. 3 weeks. Prayer not being opposed by.
My lord, if that is not.
So you should oppose.
I oppose, my lord. Vehemently oppose.
Considering that MSP Pango is having a personal difficulty, list this matter after 3 weeks, so as to enable the London State Council to file an additional affidavit as directed by this court, as sought on 9/10/2023. This after 3 weeks.
My lord, may I pray for a date, my lord, if it is not inconvenient? My lord,
I have no inconvenient. Inconvenient they may have. You decide among yourself,
19
between yourself,
19 December. he has
19 December.
Deeply,
List this matter on 19 December.
deeply.
Yes. Item 7, nothing.
7, my lord. this
You
is-
have accepted the compensation. You may have every right to
My-
get under the 2013 Act.
My lord.
But
The-
there is,
The
you have
pro-
not protest, there is no protest.
My lord, the problem, my lord, is there is
You
no
are the
award.
villager, you don't have the, you are ignorant.
That may be one, but my lord, the fact remains, my lord, that we have to protest it against an award. There was no award, my lord.
But then you have accepted,
We've
without the award, you have accepted.
My lord, but that award has to be there, my lord. Because we
There-
have
there-
to go
there-
in reference.
According to this code, is mere technicality,
My lord,
not a fundamental right.
my lord, the reference lies from my lord, the award. There are many decisions on this, my lord. Then-
Affidavit, any
but-
affidavit,
The DC's affidavit is essential, my lord. That was submitted on the last date, my lord, because he is the authority. The DC's affidavit is essential. That is not.
That's where problem is you have accepted it.
My lord, but
Happily you have accepted it.
my lord, the problem, my lord, is to take recourse to the remedies, my lord. We have to apply for reference against the award.
This court considered it just an aberration. It's not a complete violation.
My
Yeah.
lord,
You have not protested. And you have happily accepted it.
my lord, I would have a different take on that. Without
What is the status of the land?
Well, it's already, possession has already been taken, my lord.
Taken?
Possession taken. We are not opposed to that.
Except the flagging has stopped the
Oh,
service.
Oh, that is bad, my lord. If they have
That's
stopped,
why
if
we
they've
are facing lots of difficulties.
oh, that is inconvenient. I'm told, my lord, they have only 2 aircrafts. So that is one problem.
So,
And-
Here also yourself, I'm seeking for adjournment.
ah,
Mr. RH now due to death of his relative, he's
is it
left Dhananjay also.
heard Mr. Pidina learned consider the petition. Mr. Vairira, learned government council, service there. Mr. R. Nabam. Learned additional advocate general. Who is appearing in this matter is in bereavement.
Yes,
Bereavement. Therefore, the matter may be listed after 3 weeks. Prayers along. The state respondents may file their affidavit in opposition in the meantime. This after 3 weeks.
My lord,
On 19.
my lord. Deeply obliged.
Sir, go to Keba, what is?
No, my lord, without.
Keba is the for a state like Arunachal Pradesh, or for that matter, notice, some part of the notice, is better go to Keba. At the local settlement thing. What is there?
My lord, I respectfully accepted the opinion of my lord. My lord, kindly see it.
LCR is yet to be received.
Okay.
So we'll wait for that. That's it. Office not so sir.
Yes.
LCR called or what? What
LCR.
LCR will be there?
Record, I don't know.
You are against the
Kaba.
It's
Keba.
not decision, it's against the, I think, the initiation of
Parwana.
process, Parwana.
Parwana.
I think LCR may not be required.
What is the issue?
No, no,
Dispute. I mean, dispute.
No, the dispute was relating to a constructions of a small road. And there that has occurred, that place of occurrence is another place. And the Gamburas of another place is issued the Parwana. So 2 things will come up.
Jurisdiction.
Jurisdiction. First, the place of occurrence, the first village authority will have the jurisdiction.
We'll set aside the Parwana and we'll ask, directed you to approach the parties to approach the village authority who is having the jurisdiction.
That is there, my lord. My lord, so far jurisdiction is concerned, my lord.
Or it is something more than the jurisdiction.
No, here, my lord,
We have-
earlier, my lord,
We had this scene.
earlier section 40, my lord, unamended section 40,
Yeah.
1945 regulation.
Yes.
For jurisdiction, the parties were required to be within the jurisdiction of the village authority.
Yes.
That has been done away. Now, amended under Arunachal Civil Act, that is not the requirement. So if I understand, if my understanding of the Arunachal Civil Code Act, it says that customary code. Now, customary code, it includes that the authority of the traditional council or authority of village indigenous to the state by whatever name may be called. So, including the village authority also. So here is the case, Your Honor. So far, that portion, my lord, I leave it to my lord because
No, in that case, if you interpret that way,
my lord.
it will have a conflict
No,
with the unamended provisions of the regulation, which would not have been the intention of the legislature. We have to interpret that. way.
That part is
We
there.
cannot interpret.
And there is another
unless
aspect.
It clearly, I mean, contradict.
My lord, that requires to be clarified by this, or that needs to be clarified. Another aspect, my lord. Because here is what happened is Gori village, Ganguras, they will be having interested party, my lord. Why I'm saying? Because it is the lane, it's the road constructed in the Gori village, they have been problem. So they are the interested party. So Arunachal Civil Code Act says that if the Ganguras are interested party, they should refrain from taking participation in the case. So in that situation, only the remedy is like, my lord, that the district level Gangura should initiate the matter, my lord. Because, my lord, even if my lord says that
This road covers only the one
within Gori village.
within Gauri village.
Yes, ma'am.
Has it been constructed?
That was, my lord, under construction, almost completed. Then the petitioner came, she completely damaged. Complete, openly. So now the issue, my lord, even if this matter is taken by the Gori village authority, my lord, if we say, my lord, that cause of action village authority will have jurisdiction only where their cause of action is there, even if we say, which is not there otherwise, my lord, in the act, my lord. I have seen, my lord, both the act 1940 as well as this Arunachal Pradesh Civil Act. Now earlier, my lord, the requirement was the
next day, and
Normally you have,
it is next para. It is said that this court has called for the LCM. However, in the effects of the present case, and the nature, in view of the nature of the present case, there would not be any LCM except the impugned for one. Therefore, no LCR is required to be called. So we have modified our earlier order that no LCR shall be called.
correct.
Since there is no LCR.
The authority, no record is there. Much of. Grateful, as we continue, right? Grateful.
Yeah, your lordship. Lordship, on 14, when this matter was listed, the only question that was put before the.
Whether
he was-
further
Yes, Your
introduction is required. No required.
Not required. I have taken instruction from my.
Heard. Miss Artaku,
Yes, your lordship.
learned counsel for the petitioner. Petitioner accused applicant.
Yes, your lordship. Yes, sir.
This is an application under section 413 and about 1974. Praying for post arrest. Of the accused Sri Taro Liaksona in connection with usually PS case number 94 of 2003 under section 306 IPC 18, 1860. Who has been arrested on 10/10/2023. Only a month, more than a month.
More than a month. As of today, it's 38 days, your lordship.
Here's the FIR.
FIR, your lordship, it's in page number 14. And the type copy is in page number 16, your lordship.
The next one, the case set up by the prosecution. An FIR was lodged on 9/10/2023. That young alias Eliza Hassan is found hanging inside the rent house near Fort Diller, Lekki village. It is alleged that as per the reliable source, thoroughly son of the accused was a boyfriend and he used to torture her anytime which was reason the deceased. It is also alleged the torture witness many persons who were witness to the torture depicted by the accused to the deceased. The mobile phone of the deceased was switched off on 6/10/2022. After the parents started looking for deceased. And the brother of Thoroughly is the same accused.
Yes, Your Lordship.
On the body of the brother of the accused has first found the dead body of deceased. Pursued the this was released. It's usually be choice. Arrested on 10th April 2020. Mr. G. Tado, deputy message from the officer in charge this station maybe 15 the officer in charge and is accused is no more required as per the considering the above. This court is to allow this application accordingly. The accused applicant says so and so shall be released. Then on promising a bail bond of 20,000. Like we do seriously like to the satisfaction of the court. Which court?
Sessions Court.
Sessions court. Yeah, the session court. The following conditions. What are the conditions you would like to put it? The accused actually the applicant shall not tamper with the evidence and the witness. Expert. The accused shall appear before the IO or the court as in when called for. Expert. The accused petitioner, the accused applicant shall not have the jurisdiction. This is called. Yes. UP. Okay. That's prior permission. Congratulations.
Much obliged.
These are 439 application, my lord. The FIR, my lord, is at page 20. It's not an APSC scam, my lord. My previous bail applications were rejected. But the main accused, my lord, he was granted bail by the Supreme Court. If my lord comes to page 41, that is the Honorable Supreme Court's order, whereby he was granted bail. If I may be permitted to read some portion, my lord.
Charge sheet has been filed.
Charge sheet, part charge sheet, and the next date is for filing of supplementary charge sheet. My lord, page 42, if my lord comes to the Honorable Supreme Court's order, my lord.
42.
42. This is in respect of the prime accused, Mr. Taket Jairam. Perusal of the materials placed on record, paragraph 3 of the page 42. Perusal of the materials placed on record would reveal that 7 out of the 10 accused persons have already been released on bail. Insofar as the apprehension of the prosecution regarding tampering with evidence and influencing the witnesses is concerned, the same can be taken care of by imposing stringent conditions. It is further to be noted that the petitioner has been incarcerated for a period of more than 1 year and charges have not yet been framed. In view of the matter, we are inclined to grant bail to the petition. Thereafter, the conditions. My lord, I am the father of one of the aspirants, my lord. I am not involved with the examination process, my lord. I am a father. And I have taken loan from some people. My lord, I would not say much on that, my lord. But, my lord, I am not involved in the examination system. I'm not a part of the system. I'm a father of.
When you were arrested,
My lord, 30th September 2022. My lord, 13,
more than a year.
more than a year, my lord. 13 months and today is 18 days, my lord. 13 months, 18 days. 1 year, 1 month, 18 days. My lord, may I pray for some parity, my lord, with the Supreme Court's order, my lord. On that, my lord, there was one judgment also on parity. One smallish order. My lord knows that now. So,
No, we don't know.
my lord, para 4. Having granted bail to the co-accused persons against whom also the same allegations are raised, we are of the view that there is no justification in denying bail. Just this line, my lord. My lord, on the same conditions or even stringent conditions, whatever conditions, because my lord, I had to undergo a surgery, my lord. A rod was inserted in my thigh bone, in place of my thigh bone, for which in fact I was referred to Negrims, but because of certain things it was not done, and I am still limping, my lord. So during my custody period.
That will be your medical problem will be taken care of by jail authority. We'll direct that.
My lord,
We'll direct that.
but I pray for some parity, my lord.
What the Supreme Court will reject it.
My lord, my lord, Delhi is too far away, my lord.
Doesn't matter.
It's too far
We
away.
have a good connectivity now. You can take directly from here, Colombia.
My lord, it's too far, my lord. And my lord, he had to take loan, my lord. I'm not admitting anything, my lord. Just off the record, he had taken loan, my lord. He is not very well to do also.
You are admitting it. You
I'm
have
not, that's why I said it's off
taken
the
a loan and paid it to the whoever.
My lord, this is off the record. My lord. This is what has come from the opposition, from the respondents. My lord. That's not what I am saying. The allegation of the respondent. So, my lord, I'm not admitting, but I'm pointing out to the fact, my lord, that I'm not involved in the system.
This is a menace.
I agree, my lord. Everywhere.
This court cannot comment
My lord,
more than that, but it's a menace.
it is. We had the experience there in Guwahati earlier. Of course, in Guwahati now it's a bit better now.
That we are relying now.
Lordship had referred to
Relying now.
Lordship had referred to the judgment sometime back, my lord, today morning. Rakesh Pal. But my lord, I pray for some parity, and otherwise,
Sir, what do you say? They are opposing vehemently.
my
By
lord-
filing affidavit, my lord, objection petition, my lord. My lord, the role of the accused person is directly connected in the matter, in the case.
Kingpin has been released. It's more than a year. Charges has not been framed as yet.
That is only because of the absence on the part of the other accused persons, maybe some other reason, my lord. The affidavit, my lord,
You
charge sheet has already been filed, my lord.
No.
can you show that this present accused is different in the different footing or different status where the custodial interrogation required, other than the so-called kingpin who has been released by the Honorable Supreme Court on bail.
My lord, admittedly, my lord, from the record, my lord, he is the one of the government servant serving in the other department, felicited to get in the paper.
He is also a government servant.
He was
fishery
officer.
officer.
He was fishery officer.
Agriculture officer.
What about his appointment?
My lord, long time back.
He's the father.
He's the
What is
father.
his appointment?
My lord, long time back, my lord.
Can you reopen that?
Man, that was a long time back.
How he was appointed?
That was long time back. My lord.
Can we cause an inquiry?
In fact, my lord, the action has already been initiated against these accused persons. He may not be no longer in the.
No longer in the job.
So all the persons who is involved directly in this case.
So difficulty is, I am also discouraged inclined. Unless you say the custodial interrogation is not required. We understand the liberty. But in view of this Supreme Court, who is stated to be a kingpin, really.
But my lord, exactly, he's the king. My lord, the role of the different accused persons is
That's
different.
why can you submit on that? You make an argument on that,
My lord,
showing that this man is stand alone kingpin, other than the so-called kingpin.
my lord. Specifically stated in paragraph, my lord, paragraph 3 of the objection petition, my lord. Page number, sorry, my lord, 3, page number 3, para 3 also, madam.
Affidavit
My lord, filed by the CBI.
during the course of investigation.
Yes, madam.
Just read it.
That during the course of investigation, the evidence was collected against Binam Jomang, daughter of Talung Jomang, now accused person.
He's the accused.
Yes, yes.
Talung Jomang.
Talung Jomang is the accused person. The Talung Jomang, and the Talung Jomang, during searches, the photocopy of the manuscript of the question paper for AE Civil Engineering were recovered from the house of the Binam Jomang's fiancée. The investigations revealed that the accused Taluk Jomang got the questions papers of a civil examination 2022 for his daughter Binam Jomang by paying undue advantage of Rs 55 lakhs to accuse Takit Jerang. The investigation established that the Talung Jomangs had taken the various amounts is loan from the witnesses just before the AE examination 2022. Apart from this, the accused Talung Jomangs also availed a loan of Rs 20 lakhs from the State Bank of India during the same period of the paying the undue advantage of Rs 55 lakhs to accused Takit Jerang. The accused Takit Jerang, accused Talung Jomang conspires with the accused Takit Jerang, the then Deputy Controller of Examinations, to get the question papers of AE Civil Examination 2022 for his daughter Binam Jomang. The accused Takit Jerang was handed over the sealed envelope having the manuscripts of the questions papers of AE Civil Examination 2022 giving the same to the authorized representatives of the printing press. During the process, they opened the seal envelope and took out the manuscripts of the question paper and made a photocopy of the same. Thereafter, he kept the manuscripts again in the envelopes and resealed it. And in furtherance of the conspiracy, the accused Takit Jerang, they handed over the photocopy of the manuscripts of the questions papers to the accused Talung Jomang. On the basis of the evidences they collected during investigation, a charge sheet was filed against the Talung Jomang and others on 8/12/2022 for committing.
When did you file this?
My lord.
When it was filed?
In this particular objection.
16.
16, David, yesterday. My lord.
And
When did the Supreme Court order?
my lord, page 40, 41, my lord.
When it was?
My lord, this is my lord 10/11/23.
11. Even after this,
Yes, ma'am.
even after you have said anything on this?
On the
Have you said anything?
No, my lord. Admittedly, there is no, my lord, any the statement in respect of that the bail order of the Honorable Supreme Court, my lord. However, my lord, the role of the Talung Jomang is.
Have you had the knowledge of this Supreme Court order?
Yes, we were there.
Still
and
then, still then you didn't say anything.
Yes,
On that.
admittedly, Your Honor.
Huh?
Yes, my lord. Admittedly, we have not stated anything. However, my lord,
Fix it on Monday. And we'll give them a chance to, have a instruction
My
on
lord,
this. Because
particular issue.
could it be on
this court finds that I'm not saying kingpin, not kingpin, but interrelated, the penalty can be extended to him also. Same thing.
My lord.
By this time, 1 year, if you could not find anything, if there's against this particular accused, you cannot.
Yes, ma'am.
So, though this court is not inclined in such a cases, but in view of this Supreme
My
Court,
lord.
let them take instruction. Since you have been for more than a year, another week.
On Wednesday, 22nd.
My lord, 22nd is I have already pointed on the because of that reasons the matter has been fixed today. On 22nd and 21st, I'll be having personal difficulty. So may I have written on 23rd
23rd.
or 24th? Or on Monday, subject to convenience on the first.
Indication, this code indicates
My lord.
it's penalty can be extended.
Yes.
Had it not been this Honorable Supreme Court order
My
related
lord,
to
exactly.
the other accused,
Exactly. ma'am. The other,
we could have, this court could have rejected.
yes, ma'am.
to
My
the
lord,
extent.
yes, ma'am. Other submission, my lord, regarding medical part that have
But
already
you,
been
you
taken
have,
into consideration.
in view of this,
Yes,
because
ma'am.
you have not said anything on this. Of course, you cannot, but then have a verbal discussion with them and appraise them also.
Yes,
You
madam.
think the court is inclined to extend the penalty.
My lord, regarding that matter, my lord, in fact, I discussed with the officer concerned. My lord, this is the routine manner of the CBI to file an objection, but without making such observations on the,
Now, things are changing.
yes,
The history of the bail and the procedure of, in the court. At one point of time, it was strict. In between, there was some liberty. Ultimately, nowadays the question liberty is utmost.
Madam.
Vis-a-vis the fair investigation. So, modern year, if you cannot do anything, and if you have done it also, because arrest is not a punishment as such
Correct.
during the investigation. Proceed with the trial. Since you have the subject to further investigation, you would like to. Why the charge cannot be framed now?
my lord, exactly, we haven't any
You just
information.
said unavoidable circumstances.
My lord, we don't know.
This is one of the reasons Supreme Court said charges has not been framed even after the year.
Charge sheet has been filed long years back,
Charge sheet has been filed.
long days back.
But they have
It
taken,
indicates something. It indicates more than what's meets the eye.
My lord, here, the problem is there are so many accused persons. Maybe that could be the one of the reasons for non-framing of the
You
charge.
work it out. You are the one.
Yes, ma'am.
Prosecution. Work it out.
Yes.
24.
23rd.
23rd, ma'am. I'm
On
sorry. my
the
lord.
joint prayer of the learned council to the purchase. This matter on 24.
23rd.
Ma'am, 23rd.
23. 11, 20, 22.
Deeply obliged, ma'am. My lord, in this matter, this honorable court has indicated regarding my lord, the contention and prayers made by my lord, the FLN regarding my lord, there is a head collision for which my lord, we have been already directed for payment of the 50% of the amount, my lord, that we have already complied with. And I believe the other party has also received the my lord, amount already
You are
deposited with the
supposed to
register.
take press steps.
On several occasions, yes, admittedly, we take it.
Take press steps. It's ordered.
Yes,
Had Mr. M. Katolan, counsel to the petitioner, and also had Mr. M. Body, learned counsel appearing for
1, 3, and 4.
respondent number 1, 3,
3
and
and
4. Next para office notes dated 16/11/2023 indicates that the learned counsel to the petitioner has not taken steps. Has not taken steps for service of notice upon respondent number 2. The learned counsel to the petitioner said we may be permitted to take precise step. Please, sir. No, that you deleted. The learned counsel for the petitioner is directed to take fresh steps within 3 days
My lord,
for service of notice upon the respond number 2. List is better after 4 weeks. After fresh steps,
deeply obliged.
what's to be done?
May I please, Your Lordship? Your Lordship, on the last occasion, I was directed to take fresh step. Through registered as well as Dusty.
Have you taken?
Yes, Your Lordship, but could not take the Dusty service. Could not take the Dusty service, Your Lordship.
Mr. So learned counsel for the petitioner submits that he may be allowed 3 weeks time to 2 weeks, 1 week.
Your Lordship, we have already taken the
Submits that
service
he has-
through registered post.
He has taken fresh steps for respondent number
Two,
for service of notice upon respondent number
two, Your Lordship.
on when?
I forgot the date, Your Lordship, but we have
Find
taken.
out and give that on so and so and that. Huh?
Yes, Your Lordship.
Mr. G. Tado.
And Your Lordship,
Learned additional people present.
further, I may be allowed to take Dusty service through her council, Your Lordship. Your Lordship, there is a case going on, maintenance case is going on JMFC. So Your Lordship, I may be allowed through her council.
Make a submission, not in one go, not in a piecemeal. Then delete all this. Mr. So and so, learned counsel petitioner submits that though he has taken fresh steps, service of notice upon respondent number 2, nah?
Yes, Your Lordship.
By registered post with AD, he may be allowed to take Dusty system. And the learned counsel for the petition is permitted to take Dusty service, take steps for Dusty service. List this matter after 3 weeks.
Much obliged.
Mark his present, Mr. G. Tado additional present.
My lord, this is criminal appeal against acquittal filed by the state. In this case, my lord, the leave of appeal was granted by this honorable court. But however, my lord, the notice upon respondent number 1 to 5 are
Still awaited.
still awaited. So I may be allowed to take a fresh step, my lord.
Mr. J. Sri learned public prosecutor submits that he may be allowed to take fresh steps
Upon all the respondent.
for all the respondents. The learned PP is permitted to take fresh steps within 2 days, 3 days.
3 days, my lord.
3 days. List after 4 weeks.
4 weeks.
May I please, Your Lordship?
Yes.
This is an application filed under section 482.
What is to be done today?
Orders, my lord.
After perusal of the records, Lordship, the service report is still awaited, Lordship. Private respond number 2 to 6.
When did you take the steps? You take fresh step? Huh?
Lordship,
1 to 6, yet to be received. When did you take the step? 12/9.
Lordship.
No, long time back. You take
Long time.
this, office note indicates that, office note that is 16/11/2023 indicates that services upon the respondent number 2 to 6 is not yet received. The learned counsel petitioner is permitted to take fresh steps upon for service and notice upon respondent. Within 3 days, what, 4 days? List after 4 weeks.
Lordship, may I pray that, Lordship, since this matter is pending before this honorable court, Lordship, the trial is going on, Lordship, and the lower court, Lordship. Now we are basically in this petition, Lordship, we are challenging there are 5 FIR has been filed by the different position, Lordship, for the
It's
same
okay,
facts.
it's okay. What do you want?
Lordship, the trial may be stay for till the disposal of
File
this.
an application. Long time back, it was not considered, or
Lordship.
rejected. It was not considered. What is
Not,
the
not,
offense?
not considered.
Lordship, the offense, section 120B and 147, 148, 149, 436, 124A, 153A, read with section 3 and 4 of PDP Act, Lordship. The charges has not been framed so far, Lordship. Now, Lordship, the fact of the case is that, Lordship, they're all the petitioner, Lordship, they're the villagers, Lordship. The incident took place on 11/12/2022, Lordship, 2020, Lordship. There was a angry among the
We'll see after if there's a valid application.
Lordship.
List after 4 weeks, huh?
Lordship. Review. Lordship.
Lordship, service is awaited on all the respondents.
Office note dated 2011/2023 indicates that service is not. Upon respondent number has been received.
Respondent number 4 is being represented, 5 to 8.
5 to 8.
Yes.
No, only it shows 8. You are for 4. Yes, sir. I've already filed my appeal. Office note only about 8.
8 has come unserved, Your Lordship. Rest of the 8 has not.
Others,
It's not.
and for respondent number 1, 2, 1, 2, you are for
I'm for 1 to 3, Your Lordship.
1, 2, 3, and then
I'm the
Then-
petitioner.
and then 5, 6, 7, huh?
8, 5, 6, 7, 8. Is 8,
8 return answer, huh?
yes.
And for respondent number, there's no office, office note doesn't indicate about the other response. In view of the land council petitioner is permitted to take the steps upon respondent number 5, 6, 7, and 8 within. Within 4 days. This after 4 weeks.
Kindly this matter will be taken up on Monday, Malad, or Tuesday, Malad.
No,
Sixth and service.
you take fresh steps. Because return answer means what? You find out the correct address.
Malad, may I kindly submit, private respondent number 6, 7, and 8 are the daily wages. So according to their comfort, they find new job at the new locations. So
You
it's-
find out that is your job.
So, Malad, this is the 6th time we have sent copies, Malad.
It is your job to find out the correct address, sir. Please, I pass the order after 4 weeks. You take press within 4 days. Or within 1 week. Within 1 week, you find out the address and send it. All right.
Be pleased, Your Lordship.
What is this, sir?
It is IA for condonation.
Okay, notice.
So we have
Notice has
filed
gone.
on make appeal.
Service is awaiting report of this sole respondent. Ever service reports? We'll wait for some time. Ever service report on the sole respondent. List after 3 weeks. Because your steps is hardly a month,
Yes,
nearly a month.
this is, my lord, the amount is no matter, but in the impugn order, there is some
Go,
error.
what error?
Because the same matter had already been dismissed by the state tribunal in the year 2014, but thereafter.
How to reconcile that?
Again, without any restoration.
How to reconcile it?
Sorry, sir.
How to reconcile it in such a situation? You tell us.
Yes. No,
You are not agreed by the quantum,
yes.
only the error.
Oh, error.
I don't know whether this can be corrected by the tribunal. Can it not? Mr. Sona? They are not agreed by appeal is being filed
Yes.
against the error that appears to have been cropped up.
Yes,
in between two, because of the two claims.
two claims.
So how the appeal
Same,
lies?
same party.
Can he, tribunal, there's no review, no review lies.
Review
on what?
this,
That's what I'm saying.
this applies.
Think about it. That will be unnecessary if you are not challenging on merit in an appeal.
Yes,
If there's just an error, you can file and review,
so
or
that
get it
effort,
corrected.
my lord, that effort, that is,
If there is anything more or more
yes,
ground, then
something more.
then we'll see. You
Something more.
said
Something more, my lord. Something more is there. I'll satisfy myself.
okay. What is this?
This IA has been filed for vacating the interim order granted by this honorable court, Your Lordship.
My lord, not only I think this matter can be disposed of today itself.
What?
The issue is very simple, my lord. That we have to show to you, my lord, that whether there is two judicial proceedings for the same subject matter between the same parties or not.
Let us see the impugn order, page 11.
Impugn order is there. Page 11. My lord, as per this order and the petition, they have misrepresented the fact that the 16th decision was a cover decision. It was not a cover decision, it was just a family sitting. Though the complaint was made by the wife of the petitioner before the head Gambura, but instead of conducting cover, he has arranged a family sitting.
If Your
So
Lordship,
in the family sitting, the necessary party, the petitioner, he has not turned up.
if Your Lordship
Who is
may,
Dongam Jili?
she's my stepmother, Your Lordship. The main issue in this entire petition is that a court taking up an letter of administration, Your Lordship.
Petitioner is your father.
Yes, Your Lordship.
Don't you care?
Yes, Your Lordship.
Thank you.
Therefore, I was taking time, Your Lordship.
You engage someone.
Yes, Your Lordship.
Lordship, in the meantime, may this
Next week, you engage somebody.
Yes,
Lordship,
also, Your
that
Lordship.
Parwana has already been issued, then any time the meeting could be conducted.
No,
You are against the Keba.
We have already filed LA application before.
LA application, not LA's application is only for letter of
Next week,
administration.
we'll hear next week. what-
Yes.
Lordship,
It's a family dispute. Yeah.
Yes.
That has not.
Lordship, there is two
And
proceedings
also,
for
Your
not
Lordship-
subject
No,
matter.
no, today I can hear you. I can decide the matter, but see, this court suggests
Yes.
that she should not appear.
In fact, I may Your Lordship.
your colleague's own father.
Yes, Your Lordship.
He has already obtained lordship interim order.
Yes, Your Lordship,
okay.
that was
Doesn't matter.
out of, yes. Also,
Lordship,
Your Lordship, if I
In
may.
case, in
Is
case,
it
lordship,
more than the thing, I mean, the merit of the matter, you'll have to have equal.
lordship,
It
at
is
least,
important
at least
the
lordship, in
profession.
between lordship, at least Kava may not be conducted.
I-
This is a third time, they will pass ex parte order. Whereas already.
She said there will be no kaba.
Yes.
No,
In fact,
they have already.
In fact, Your Lordship, if I may, Your Lordship may not record my submission, but what main issue in this?
We'll take up on Monday,
Yes,
you engage some other lawyer.
yes, Your Lordship.
See,
Also, Your Lordship,
Lordship, if till such time, if Kava conducted.
no, Your
Within
Lordship,
this Sunday or Saturday.
the Kaba itself has never been challenged.
The conduct of Kaba members
How
are
can there
such-
be a stay order on Kaba?
then in that case, I'll not make you wise.
Mm,
If kaba is conducted, what you are supposed to do, that you know.
yes.
This court will not make you wise.
No, lordship.
All right.
Also,
But the problem is you have to think about is your colleague.
I understand,
Yes.
lordship, but the conduct of Kava is such that
It's
they may
not,
conduct
in
meeting
future
anytime.
also.
yes, in fact, what has happened, Your Lordship?
Have you
Or
realized?
else, lordship,
Yes,
Now realize.
No,
But
no.
before filing, you should not.
before filing, Your
Before
Lordship.
filing, you should have
Before,
realized.
before filing, Your Lordship, we'll see that in the Wakalatnama also I had other counsels, Your Lordship. Unfortunately, on the day of when the matter came up, they were absent on that day. And
Doesn't
having no other option, I had
Does-
made my
Doesn't
submission.
matter. Doesn't
Yes,
matter.
Your Lordship.
Doesn't matter. Never commit the same
Yes.
thing.
lordship,
Your Lordship, if
whatever
I,
time,
if I
let
may,
her
Your
tell.
Lordship.
My only prayer is the letter issued Kit Kava will not be conducted in between
Ah,
this.
How can, when the Kaba itself is no challenge?
That
How
means
can
that-
it be? That's an absurd
So
submission.
lordship, the conduct of
Just
the
wait,
Kava.
just wait.
Yes,
She
yeah.
said the Kaba will not be conducted till Monday. If it is conducted, you have
But if I,
you may take.
if I portray before your lordship, the conduct of Kava member.
If I may pray, Your
We are
Lordship,
apprehending them,
they
may
have
conduct
filed
Kava
it.
anytime and
No,
pass ex
problem
parte
is,
order.
I can hear you. I have, this court has enough time today also. But
Yes.
then problem is the proper.
On my part, Your Lordship.
Huh?
Also, Your Lordship, if I may, in that case, because when an
Never do this again.
yes, Your Lordship, when an IA has been filed, Your Lordship.
Let it be dismissed, but then you should not appeal.
Yes, Your Lordship. The IA has been filed, Your Lordship. At least give me a week's time to reply because there are other allegations.
Your lordship, issue is very limited.
No.
Because the IA has filed, yesterday only I was given the copy, Your Lordship. The IA has been filed, at least I may be given time to file
Yes.
my reply.
No, why I should record your name again if I don't want to hear you, if this court doesn't want to hear you.
Yes, Your Lordship.
But the lordship, in spite of hearing them also,
Well,
the
say,
order may be passed.
heard Mr. M at the learned counsel for the applicant. The petitioner opposite party is given 1 week's time to file an objection to the IA, so and so. I'll not mention your name.
Yes, Your Lordship.
List this matter after 1 week. It's their right to file an objection if they want.
But if the Kava conducted, then the
Then you
matter will become.
recourse to the remedy permissible under the law.
Deeply encouraged.
Obliged.
Mother and son, yeah. You understand. Or else I'll recuse from this matter.
Obliged.
Deeply encouraged.
he is no longer interested to proceed with the case. How can he say so?
Because
He may not be. In that, if you are not interested to proceed with, you have to issue a notice to your client.
that this is an application under
You, this side, that side, were because of the litigants only were here.
the civil suit was filed, Milord. What had happened was the learned court below came to pass an interlocutory order. So interlocutory order, if someone has to challenge, it is under Order 43, Rule R of the CPC, not in the form of Section 115. So that is the case. The revision is not mentioned. The Antox India is there and all other things. But my conscience, ethically speaking, it's not proper for me to proceed ex parte to my mind, Milord. Because like that's only I'm praying, Milord, today, let this interim order be in view of the
Mr. Titi Tara, learned counsel for the respondents in all the cases.
all the
Respondents. It is noticed that the learned counsel, Mr. Deepang, learned counsel, who represented the petitioner, appellant, appears to have made a statement that he is no longer interested to proceed with the case. And proceed with the case. Therefore, he wants to withdraw his name from the post as the counsel representing the petitioner. But then his name is still shown.
No,
It's not so.
no, his name is has been stricken.
There are so many other lawyers in that case.
So but they are also no more representing in this case. Tabatagum Dilip Mojumdar sir was there earlier, and then brief was handed over to Brother Pangin. And
He is the last man.
as the last
Lawyer to represent.
last.
Mr. However, it is at the same time, it is seen that other than Mr. Deepangi, there are batteries of lawyers reflected in the cause title. Mr. If nobody appears the next day present the petition, to represent the petition, the interim of the first shall be vacated. Considering the fact that the materials pending since 2002. Mr. Titi Tara, learned counsel to the respondents, fervently and vehemently urged that in view of the order dated 14/9/2022, the interim order was vacated. Considering the above, the interim order was still vacated. However, since there is batteries of lawyers, it appears to have been representing the petition. The learned counsel, the learned counsel appearing to the petitions are expected to issue a notice to the petition in case they are not in in a position to appear on behalf of their clients. On behalf of petitioners public defenders. Since the letters, it is also provided on the next text. If nobody is representing the petitioners or respondents, same behavior. Same added consider, added disposal. This is after 3 weeks or 4 weeks. Maybe after 6 weeks. This is after 4 weeks. 4 weeks. They come anytime if they are agreed. But the council also not.
No, but
You just appraised them, Mr. Tagum,
I
Mr.
spoke to,
Majumdar and all.
well,
this.
I spoke to all of
You
them.
just cannot withdraw like this.
I spoke to them.
This court especially will not permit.
So Milord is saying on one perspective that Milord, mother-in-law.
Despite service of notice, I mean, sending of notice. If they are, have they received of the note, after this, even after receiving the notice, if they don't, take steps, then we cannot.
Statutory appeal, Milord.
But it doesn't say,
cannot
it
be
doesn't
disposed of
indicate in the
without-
records.
Statutory
that,
appeals cannot be disposed of without hearing. But in criminal law, Milord, I think Madan Lal Rathore versus Rajiv Thapar were reported in 2007, 7 SSC 623, Milord. It has held that appeal cannot be disposed of without hearing. Statutory appeal. And this is further reiterated very recently by the Apex Court in Taj Mahmood case in criminal law. Civil, I have not come across it. Probably that principle in the Rajiv Thapar case might be applicable.
There is some more judgment.
I'll
on the
have
issue.
to.
You find it out.
Yes, I'll just find it out.
So when we're dealing with the civil, we should go with the civil cases, civil judgment, not the
Now
criminal.
this I am having right from Antox India 1982 SSC page 456, that paragraph 8 and 9.
Just right. That's just right.
ONGC. Just
right. Let us see.
And ONGC also where Justice Mehdi appeared.
Just give the citation. Just write the citation.
Yes, I just. Antox India, taxing is there, but taxing versus 2019. 0 AIR SC 1047 is taxing law.
What does it is?
Yes.
There's no citation like 0. It's
Yes.
not
No, AIR.
accepted citation.
No, AIR, it is there.
AR there, but 0 is not there.
Sorry, 0 is not there. Sorry, AIR, sorry. 1047 is then Antox
Sir,
India
give us
private-
the acceptable citation.
Well, these are.
Because
Antox India.
as you have seen it, we found so many judgment, different publishers,
Yeah,
which
because
is
I have
not
this.
recognized.
I have this.
Very difficult.
Antox India.
And yesterday I had a big problem. I asked for the SEC, since SEC was not working online in the library. They printed out from the Manu.
Okay.
And I gave it to my PS to give to reproduce the paragraph. What had
Well,
happened,
the
what had
variation-
happened is she has reproduced but different paragraph. It's not her fault because of Manu and the SEC. There's a difference in paragraph also.
Correct, Milord. That
Manu and
even Milord, online and the offline version of the SSC, you will find a variation.
And there's
in
a
the
difference
paragraph.
in AR and SEC also.
Yes.
Even the
AIR. And then even
paragraphs.
this, Milord, Supreme today, and Live Law, they also have they also have the variation in the paragraphs. That's why I make it sure that whenever I come with the hard copy of the SSC. Milord.
SEC.
Yes. This 1990 Supply 1 SSC 727 paragraph 9 to 14, that is Antox India. Milord, this
All
all
talks about what?
it talks about that the interlocutory application under 115 is not mentioned except for the order 43.
Sir, that we have not entered into. What I wanted from you is,
Sir,
in case lawyer wants to withdraw from the case,
okay.
what is the procedure?
Yes,
That
sir,
is
that
what
I-
you are saying, 4256, something like that.
Yeah.
What is the Rajiv, something like that?
No,
That I wanted.
no,
to
no,
know.
that was
in
related-
criminal.
That was relating to the
Criminal appeal.
criminal appeal.
It cannot be dismissed on default.
It cannot be.
That is, what is that citation?
That is that Madanlal Madanlal Rathod versus Rajiv Thapar,
Rajiv Thapar,
2007,
2007,
7 SCC, Milord,
7 SCC,
page 623.
623.
And Milord, the latest is Taj Mahmud case.
Taj Mahmud.
Taj Mahmud. That citation I don't have. I have gone through.
Just give her.
Yes.
After some time. Find it out.
I'll give Taj
You
Mahmud.
get the citation and give it to me.
Yes.
If there's something wrong, I'll catch all of you.
Please, Milord. I'm always open, Milord. And also for correction.
I'm in the lighter day.
Right.
Okay, thank you.
Thank you.
Yes.
Please, Lordship. Here, we are challenging the reasonability of the impugned judgment dated 13/5/2022. Here in this impugned judgment passed by the learned tribunal, we find that the judgment was not passed on the basis of goodness, equity, and fairness. Here, the awarded amount is 64 lakh. 64 lakh, 26,000. And for the loss of deceased wife, who was housewife. So showing the monthly income 30,000 per month. So here we are being deprived by this award. 30,000 for a housewife per month income without any valid income certificate cannot be accepted, Lordship. And any judgment should be
How much
passed
you have paid as of now, as of today?
as on today.
Not paid. 50,000, that too, no liability.
No for
liability. Statutory appeal, that thing, 25,000?
25,000 and no for liability 50,000.
You pay 50% today. I mean, within 15 days. Then we'll hear you.
Today, my lord.
Not today.
Yes.
Not today.
Yes,
Within
yes.
15 days, you pay 50,
Order may be passed.
50%.
Yes.
Then we'll hear you.
Okay.
All right.
Yes.
Or are you any objection?
No objection.
There's nothing I can dispose of and dismiss it. Today itself.
Some relief may be given. At least interest is also too high, my lord.
Think
So-
that we can say. That's why I'm saying that's the reason we may reduce certain amount, but you pay 50% within 15 days.
Yes.
Can you pay within 15 days? Even let us assume if your petition is allowed,
Yes. So
reducing the interest and the income,
yes.
it will not go below 50%.
Yes.
That's the
So-
reason I'm asking.
Yes, my lord,
Because
at least I
it's a death case.
yes, that case,
My lord.
that case.
Claimant's wife died.
Yes, my lord.
Yes. So
That's right. That's the reason.
1 month, my lord, because it's a profile is there per company.
My
So
lord,
1 month.
so far, my lord, order 41, rule 3 says, my lord, it's not only 50%. This is the appeal against the money degree. It's the entire amount has to be.
So has it been admitted?
No, I think that's why I think it's in the supplementary hearing, my lord.
No, this might have been admitted already. That's why it's in hearing. 22-3.
Yes,
Appeal is admitted for hearing.
My lord, that's why.
50%, my lord.
But obviously,
Yes.
housewife cannot have 30.
No house.
Yes.
That has been proved during the trial, my lord. She was selling chicken and she was doing the traditional local.
Any reliable income.
Reliable document, my lord, income certificate issued by the executive magistrate, my lord, by the concerned authority, competent authority. Yes, and my lord, during the trial, there was no dispute. And my lord will see now recent judgment, my lord. Housewife,
What
my
is
lord,
the, what is the provision?
my lord, order 41, my lord. Order 41, rule 1, subclause 3, my lord. CPC, my lord. Rule 1, subclause 3, my lord.
Just read.
Where the appeal is against a degree for payment of money, the appellant shall, my lord, the word used is shall, within such time as the appellate court may allow, deposit the amount disputed in the appeal, my lord, or furnish such security in respect thereof as the court may think fit.
It's a money decree.
That's right. In case of other degree, this is
The
not
problem is it has already been admitted.
mild. Otherwise, my lord, there is no merit in the appeal, my understanding, my lord. So for housewife is concerned, my lord, I have a judgment where it says nowadays, my lord, notional income is taken, even assuming that she was a housewife. And some of the judgment, my lord, the housewife has been given 25,000, something like that. Even if it is assumed that she is a housewife, she was a housewife.
But I've seen it.
Yes, housewife.
Even-
Housewife service has been respected nowadays, my lord, because it was not figured. They serve us like anything, my lord. Their service is something unbelievable, my lord. And but unfortunately, we have someone notional income now. At least we have realized very lately, of course. But now it's
According to how much he's entitled.
Yes, for
Roughly, approximately. If it is
they so
according
for
to if there is a reduction in if we
they for
note down
so for
the
30 lakhs only.
30 lakhs.
Yes,
So we'll direct them
30.
my lord.
50%.
The pending, it will be remain pending.
This will remain pending. On the deposit,
Then
subject
it
to
will
the
be-
deposit of 30%.
Yes.
50%, my lord. My lord, 50%.
50%, yes.
50%.
50%.
Small, 4 children.
It's fair enough. He is also fair.
Yes, yes, my lord.
Even if
My lord.
appeal is allowed,
Yes.
according to
My lord.
30 lakhs.
Yes.
So it's near
My
about
lord, my- yeah, 50%.
Isn't it? Heard Mr. Udeka learned counsel for the appellant and also heard Mr. also learned counsel for the claimant. Respond number 1. Only respond.
Sole respondent.
Respondent.
Sole respondent.
Oh, sole respondent. Sole respondent claimant. Having considered the matters in entirety, the appellant is directed to deposit the 50% of the awarded amount. Before, where it should be deposited here, before the registry. Within
1 month.
1 month. On such deposit, the claimant is permitted to receive the same. and the matter be listed for final disposal.
Yes,
After 1 month, you deposit, within 1 month you deposit,
yes.
and he'll be permitted to take the amount,
Yes,
and then this will be listed for him after.
Much of deeply.
So we cannot fix the date now.
Yes.